Okay, good afternoon, everyone. Thank you for coming. I'm State Senator Len Suzio. I represent the 13th Senate District, which is Meriden, Middlefield, Middletown, Cheshire, and I will not leave out Rockfall. I've called this press conference to call to the public's attention what I consider to be a significant scandal. I believe the implementation of the early release program for violent criminals has needlessly endangered the safety of the public in general and the victims of crimes in particular. Moreover, I believe spokesmen for the administration are guilty of a cover-up by hiding the danger from the public itself, by insisting that the new law is, quote, tougher than the old law, and by issuing contradictory statements. I have yet to hear from Undersecretary Lawler how a law that was intended to spring violent criminals from prison years ahead of schedule is tougher than the law that preceded it. Sometimes, in fact, criminals are out of the prison before the victims are out of the hospital. Last year, I voted against the new law because I recognized the potential tragedy when violent criminals are prematurely released from prison. Little did I realize that my worst fears would be realized virtually in my own backyard. On June 27th, store owner Ibrahim Ghazal was murdered in cold blood, and the man charged with that murder is an inmate who had been released under the early release program. The murder occurred 4 blocks from my house, literally within shouting distance. If there's a poster child for the problems with the early release program, it is Frankie Resto, who had been in prison for armed robbery and was known as the Razor. We prepared a summary. I want to thank the Record Journal, by the way, for doing the research it did. They ran an excellent article today about some of the history of Mr. Resto and the parole board hearings and some of the bizarre behavior he exhibited in prison while earning early release time. When I reviewed inmate Resto's violent criminal record, I wondered at the time how he possibly could have been released from jail before serving his full time. So I wrote to the Commissioner of the Department of Corrections, Leo Arnone, and I asked a series of questions. The Commissioner responded by giving me a long list of the behavior modification programs in which inmate Resto had participated. He identified 6 programs and approximately 50 sessions in which inmate Resto had participated. When I asked him what medical or psychiatric evaluations had been considered, I was told, quote, there is no current requirement to specifically review an inmate's medical or psychological history prior to receiving credits. I don't know about you, but I was stunned by that response. To me, it's incredible that a prisoner with a history of violent crime could be released into the public without a professional opinion about the risk to the public. But that was the case with inmate Resto, and apparently is the case with the thousands of other convicts who are being released early from prison under the new law. In fact, just the sheer number of people released is stunning to me. 7,589 people so far, criminals have been released from prison. And I want to point out, this is another example, by the way, of the contradictions the contradictory statements made by administration spokesmen. As I said to you, I have a written statement or a response from Commissioner Arnone saying that there is no requirement for medical or psychological evaluations. But last night, as I was watching the Channel 3 news, I heard the reporter say that Commissioner Arnone had assured her that every prisoner is subject to psychiatric evaluations. I suspect there might be a little bit of Jesuitical reasoning here. I strongly suspect that every prisoner does eventually get some kind of psychological evaluation, but what we're talking about in this program are exit evaluations. When people who have a history of violent crime, when criminals are about to be released into the public, it seems to me to be a minimal thing to do, especially when they're going to be released prematurely, long before their term of sentence is up, that it's a prudent thing to require professional medical evaluation of the psychology of the prisoner and whether he or she continues to represent a risk to the public. But incredibly, even that little minimal standard is not implemented. And boy, I'll tell you, if there's ever an indicator of the failure of, quote, behavior modification programs, the Resto situation is it. As I mentioned to you, the Commissioner pointed out to me that inmate Resto had participated in 6 different programs and participated in 49 to 50 different sessions. So it took only Prisoner Resto 2 months when he was released from prison to become involved and accused of this violent crime, the cold-blooded murder of Ibrahim Ghazal. Yesterday, I received a letter from Michelle Cruz, the state victim advocate, in which she revealed to me even more alarming information about how the early release program for violent criminals is being implemented. Ms. Cruz pointed out that the risk reduction credits are being issued for participating in behavior modification programs unrelated to anything to do with the criminal behavior of the inmate. They can get credit for participating in behavior modification programs that are not the course of their social maladjustment. She notes that the calculation of the recidivism rate itself is artificially depressed by not counting numerous criminal acts under various circumstances. In a few minutes, Ms. Cruz will get into a little more detail explaining to you exactly what those issues are. Because of the serious questions of public safety raised by the implementation of the early release program, we are asking the administration to suspend the implementation of the program pending a review of how it is being implemented and public safety put at risk. And we are asking for recommendations for protecting the public and crime victims themselves. And there is an urgency to this because we cannot wait 10 months for the legislature to convene and pass a law. Every day, dozens of violent criminals are potentially being released on our streets under the current program. As I said, I was shocked by, overall there's been 7,500 and I think it's 89 criminals have been released under the program in the 9 months since it's been implemented. It will be too late to protect the public if we wait till next May or June for the legislature to pass the law. The law that was passed that contained the early release program gives the commissioner of the Department of Corrections considerable authority and latitude in the implementation of the program. In fact, it authorizes him to withhold any early release credits for, quote, good cause. And ladies and gentlemen, I can't think of a better cause than the public safety itself. And that's what these questions I am bringing up are involved. We want to know, why are psychiatric exit evaluations not required before early release? We want to know, why aren't lethality assessments required before the early release of a violent criminal from prison? How are the credits being calculated and actually applied? And why aren't instructors who are giving these courses, the behavior management courses to the inmates, why aren't they actually evaluating the impact on inmates? All that we can determine is if you sit there in a class, you get credit for it, whether you're asleep or not. And it seems to us that if these behavior modifications are supposed to be effective, then there ought to be instructor evaluations issued upon the completion of each course before an inmate can get credit for it. Now, I want to turn over the podium to Michelle Cruz, the state victim advocate, and we also will have someone else who will speak in a few minutes who actually suffered personally from a violent criminal. She suffered the loss of a loved one who had been murdered, and we'll give Kimberly a chance to speak in a minute too. But before that, I'm going to turn over the podium to Michelle Cruz. She can articulate some of her concerns as the state's victim advocate. Michelle?
Thank you. Good afternoon, Michelle Cruz from the Office of the Victim Advocate. For those who don't know me, I run the Office of Victim Advocate, and we do crime victims' rights enforcement in the state of Connecticut. First of all, I want to thank Senator Suzio for bringing this issue up again. I don't know if you remember, but back in the legislative session, we had asked to have this program looked at. We brought these issues up to the Department of Corrections and the Judiciary Committee, and we had hoped that we would see some change at that point, but unfortunately we haven't. I just want to unpack some of the questions that have been coming to us over the last, I'd say, 9 months or so since we've been looking at this issue since September. We have had confirmed, as of July, I believe it's 26, 2012, 7,589 people have been released through the Risk Reduction Earned Credit Program. Of those, 773 have been returned to custody for either committing a new crime or violating parole or probation. Now, it's important to understand what that really means. That does not include an offender who's been arrested and who has made bond or been released on a promise to appear or conditions. That also does not include an offender who has not been captured, who has committed a crime. So this is not a true recidivism figure. Of the 773 returned inmates, the OVA has been looking through those particular cases, and we've identified some of the more troubling new crimes that have been committed, including the following: conspiracy to commit assault second degree, a felony, violation of an order of protection, a felony, carrying a dangerous weapon, a felony, attempt to commit larceny third, a felony, intimidation of a witness, a felony, violating a standing criminal restraining order, a felony, assault second degree, felony, burglary in the third degree, a felony, attempt to commit arson first degree, a felony. These are the crimes that people return to prison with after receiving risk reduction earned credits. The other issue that Senator Suzio brought to your attention is it is unclear how the risk reduction earned credits are being administered. Specifically, we have reviewed files from the Department of Corrections where inmate offenders' accountability plan had recommended specific treatment programs. One such example was an inmate was recommended to engage in sex offender treatment and education. Instead, it appears the inmate had received credits for repeatedly participating in 2 levels of life skill programs, approximately 5 different times, and also a religion and a program on the Philippines. Those were not the 2 programs that were recommended in his accountability program. These are the issues we're talking about. Additionally, inmates have also been given retroactive credits, and this has been a little confusing for people, but when the bill was implemented, inmates could receive up to 300 risk reduction earned credits for a period back to April Fool's Day, which I think is kind of ironic, 2006. And in order to do that, their behavior would have been, we would expect, good behavior. This is one of those inmates. This inmate here received retroactive credits of 160 days for past behavior. This is their discipline record. That is very alarming to the Office of the Victim Advocate. There's just 2 more issues I'd like to bring up. On cases where the inmate offender has been released and then has committed a violation of an order of protection, which you heard there were several, there are serious concerns for violation of crime victims' state constitutional rights to be reasonably protected from the offender. That is a right the victim has to not be victimized again. And it is not reasonable that someone can engage in disciplinary action and get credit, or engage in programs that do not fulfill the recommendation by the Department of Corrections Offender Accountability Program and be released and then recommit crimes on those same victims. In conclusion, the influx of over 7,500 inmates into Connecticut's community without appropriate treatment, lethality assessment, supervision, or accountability endangers all of our citizens. I fear that if we do not suspend this program and evaluate the program, its implementation, participation, and also require some kind of psychological review before someone is released, I will be back here under more dire circumstances. Thank you.
Thank you, Kimberly. I also want to introduce to you for a few moments comments someone who has personally suffered as a result of violent crime. Kimberly Sundquist is a former president and current group facilitator for survivors of homicide. And I'm here to introduce you. Kimberly, would you like to say a few words?
Thank you. Thank you for your time, and thank you, Senator. This is a picture of my Uncle Jerry Barnett, who was murdered September 11th, 2003 in North Carolina as he left his place of business by a man who was no stranger to the prison system. My heart goes out to the family in Meriden who lost their beloved husband, father, and grandfather. Had this offender not been let out early, Ibrahim Ghazal would be alive today and his family would not be in so much pain. The state of Connecticut saved little money by releasing this individual. However, with the upcoming court fees, lawyer fees, and other costs associated with reincarnation, not to mention Mr. Ghazal is not able to provide for his family nor pay for taxes from here on out, what have we really saved? I'd like to thank Senator Suzio for being the hero we need. And again, I'd like to extend my deepest sympathies and prayers to the Ghazal family. I only wish it didn't take the loss of your loved one to take a closer look at how deeply ineffective and dangerous this law is. Thank you.
Thank you, Kimberly. Michelle, can I just have your folder for a second? Yeah, I want to show you. This, ladies and gentlemen, is a discipline record of an inmate who received early risk reduction credits. I mean, you're talking about hundreds of pages. How could someone with this kind of series of disciplinary problems in prison earn risk reduction credits under this program? Something is rotten in the state of Denmark. Something is wrong with a system that allows someone with this kind of history out of prison early. You know, ladies and gentlemen, this is a serious problem, and I do regard it as a scandal. And what we need is more straight talk and not double talk from the administration and its spokesman about this program. I would like to see the administration answer questions directly, and I would like to see reporters demanding honest and complete answers, not incomplete answers and half-truths, because that's what's going on. They're counting on bamboozling the press so they can fool the public. And it's time to demand somebody like Undersecretary Lawler explain how a situation, a new law that makes it easier, that accelerates early release, that makes it easier for violent criminals to get out of prison, how is that a tougher law? I have yet to hear an explanation that sides with any reality or any logic. So I will open this up to questions at this point in time. I thank you for your patience.